Live. Everywhere. On netrootsradio.com. David Waldman. Kagro. In the morning. Now, here's David Waldman.
Hey, good morning, everybody. How you doing? It is Friday, September 9th, 2022. Time for another show, but not for Queen Elizabeth. We actually get to clarify that now. Yesterday, we had a hell of a time reading, I guess, premature tweets reporting her death and then the retraction, which only made a joke of the whole situation. But, of course, we anticipated hearing the actual announcement any minute, and, in fact, we got it some hours, I think, after we ended the show. But everyone knows the news now, and I have no more insight into what it means than I ever did, and I admitted that yesterday. I can't tell you anything about it. My experience with, or if that's even a thing, the monarchy is watching things on television and saying, that's weird. They have a queen, and then watching The Crown, and that's, I guess, made me somewhat sympathetic toward the family. But then out here in reality, where, the not so nice part of having a monarchy that keeps all the money comes to light. So lots of interesting viewpoints being shared about it, and it's an interesting opportunity to reevaluate the monarchy and the weird constructs we build around it. Like I was reading some interesting things about, reminders like, all the fancy stuff and all the crown jewels and things like that, were taken from other people by virtue of, she's the queen and we colonized this area. So I guess we own the diamonds that are in this mine, or we own, the right to give out this land to English settlers, and they own the property and then the diamonds that come out of there. Specifically, I was reading about, did I put this aside? I don't know if I pocketed it or retweeted it. No, my pocket is a disaster at this point with all the little things, all the millions of stories going on that are actually relevant to our lives here in the United States versus, all the other number of things that I observed people talking about with respect to the Queen, where I said, okay, that's an interesting item. And I don't know, I guess I didn't put this one aside because it didn't reach to that level. But what did I read about? Oh, yes, it was somebody retweeting the word that, the royal family owns, I guess they actually own it. I don't know. If they have possession of it, I don't know what kind of word you want to use for it. But I guess the largest cut diamond in the world, or something like it, which I'll keep scrolling and I'll find the thing. It's like a bazillion carat thing. It's and of course the name gives it away. The giant. Here it is. So I saw it from Africa Archives, which will tell you, of course, what perspective this is being written from. But I don't know how you argue with the basic fact of it. So Queen Elizabeth, before her death, owned, I guess, personally, sort of, and it's a weird arrangement. It's like state ownership / private ownership. So I don't know how they would regard it in Britain, and you British people can tell me, maybe even you Canadian people, maybe even a knowledgeable American could tell me. But this was an interesting thing. So she's the owner of the largest clear cut diamond, I guess, clear diamond that's been cut. As opposed to like clear cutting, like the forest, when I think of clear cut. The largest clear cut diamond in the world. And as we said, the name gives it away. First of all, if you own a diamond that has a name, why are you not supporting this show? And it's because I'm reading facts about this and embarrassing you and things like that. You wouldn't support this show, but why don't I have your money? Give us that money. Why don't you? Anyway, the name of the diamond, which gives away the game in both ways, is the Great Star of England, Cornwall, Wales? No, the Great Star of Africa. Yes, the 530 carat gem was mined in South Africa back in 1905. Now, all right, in 1905, South Africa was colonized. I mean, it had been colonized and was, I guess, considered to be a British colony because reasons. They had gone there. They had put a flag there. They had shot some other people who had gone there and put flags there. Both of those two countries had gone there and shot some people who had lived there first. You know the story. So why does she have the diamond? And, I guess the explanation contemporaneously was, well, we're a British colony. We mined this thing. I am a loyal British subject. I find this incredible find. This is sort of an interesting thing all by itself, like minus the colonization part. Just take that out of it and put it aside for a while. You own a diamond mine. You mine the largest diamond ever, the clear diamond ever. You gotta find a 530 carat clear diamond. Like the most amazing thing on earth if you're a gem person. Gemologist? I don't know. And, I know that's the word, but I don't know who's going to be amazed by this thing. But certainly gemologists will be impressed by this and other people. And you say, wow, what a specimen. It's so incredible. I'm so lucky. I can't believe I'm so lucky to have found, quote unquote, found this diamond. Now, at this level, you're the owner of the mine. You weren't in there. Like, you weren't down there with a pickaxe. I don't know if they use pickaxes when they're diamond mining, but you weren't down there underground going, rock, tarantula. I don't know. Maybe one crawls in there. They don't just live under. Okay. Whatever. Rock, worthless. Okay. Nice. Ooh, a diamond, a 1 carat diamond. Great. Fantastic. I'm going to make a lot of money. Holy mackerel. I found a 530 carat diamond. This is incredible. Though not surprising necessarily. I mean, it's big and I'm surprised about that, but, I'm in a diamond mine. So, I'm not going to totally lose my mind at the fact that there's a diamond in there, even if it is big, but you get it up to the surface. And, I don't know, I imagine it's even larger, uncut. I don't know whether they gave it to the queen cut, uncut, no idea. Anyway, you get this thing and you're like, unbelievable. World record setting, fantastic thing. Except you didn't get it to the surface. Somebody else who you employ / enslave, I don't know, it was 1905, has brought it to the surface. And you own the mine. So they give it to you. Which is a weird concept in itself, right? I know, okay, we all understand property ownership, etc. It's a little weird. Maybe the guy who found it should be like, look what I found. I risked my life going underground for these things and I found it and I put it in my pocket. Now I don't have to go there anymore. No, I have to give it to the guy who owns the mine. The guy who owns the mine then says, I'm such a loyal British subject. I love the royalty so much. This is such an impressive stone. The only thing I can think of to do with it is give it to the British royal family to show them how much I love them. They're so fantastic that they should have this large diamond, the largest diamond. They should have the 2nd, 3rd, 4th, and 5th largest diamonds as well, plus a bunch of other ones. I can't wait to give it to them. Maybe they'll reward me with something. They'll make me a knight. I don't know. Whatever it is, they'll think differently of me. But clearly, this largest clear diamond in the world belongs in the hands of the most fabulous royalty ever. I don't know. The British royalty, mine, the one I am loyal to. So you do it. You give that away. And why? What are you doing? You could be the wealthiest guy in Britain. I don't think that would do it all by itself, but you could be from 1905 to now, you could have made a mint off of this diamond if you invested it right? But instead, you gave it to already the richest person in England because reasons. And I don't know. There's dynamics to it, right? And they get promoted and the family, I'm sure, receives a lot of favor, and maybe that's worth even more than the diamond. The diamond, though, now is estimated at about $400 million, which, funny enough, there's plenty of people in the world now running around with mega yachts and everything for whom $400 million is that's nice. I would buy that diamond. I'd like to have that. I'll give you $400 million for it. I'd love to have the largest diamond in the world. People can actually do that now. But back then, I guess they mostly couldn't. But it wasn't worth $400 million then. Anyway, the real point of this tweet, obviously, from the Africa archives was not to debate the vagaries of, a system that sets people up to become private billionaires. in competition with the Queen, but rather that it was stolen from South Africa, which now, of course, is an independent country. And, it's a sovereign nation and it's got a big budget. And I'm sure it's not pocket change there, but like they'd like to have the $400 million to deal with to take care of operations in the country. And I'm sure at some level, people are like, well, that was in the ground here. Why is that not ours? It got given to the Queen. Sure, the guy privately owned the land, allegedly, but why did he own it at all? We were colonized. They stole that. Give it back. We want the money. I don't know if they've ever made a demand for it or not, but it's a good point. And of course, Queen Elizabeth herself inherited the thing. She didn't go and take it. That's true. And you could try and decide whether you think she's at fault for colonization that mostly took place before her birth, whether she deserves any credit for presiding over the decolonization of the empire, or whether that was just something that was going to happen. And it was nice of her not to get irritated and send troops and kill everybody every single time, in all the places, though there were times. And I don't know. So it doesn't matter to me. I can't settle it. Not here on this show. I'm not, no time, not enough time anyway, and not enough expertise in it. That's for sure. But it's just an interesting thing. So here she is, or there she was, owning, among other things, this $400 million diamond because she's in this case, granddaughter, I guess, of the guy that they must have given this thing to. 1905, if it was mine, I imagine they're giving the diamond to, George, well, I guess her great-grandfather, right? I guess they would have been giving this to, like, King Edward, right? King Edward the 8th? 7th, right. 8th is the one that abdicated. Sorry, British people. Anyway, it's just interesting. So here she is sitting on, among other things, this is one of the diamonds she has on in this picture. And it's just kind of crazy. That's all. But, a good relatively compact reminder of, there's a lot of wealth in the world, and a lot of it was just given, and it just keeps getting given to the British royals, and there's no real reason why that would be, and I wonder about that, and maybe we should re-examine that. But in the second hour of the show, I don't know, I just thought that was kind of interesting, and it was actually brought to my attention by a sometime friend of the show. I don't know if he's listening anymore, but he used to listen from time to time, to our Twitter friend, Slugga Gels, Andrew Jarrell Jones, who passed this on, just saying, you definitely will never see this mentioned by any big media colleagues across the board internationally. And maybe that's true. I imagine some big media has mentioned it at some point, but it certainly wasn't the focus of yesterday's coverage. And, lots of people would argue, well, maybe it ought not to be. Anyway, we've gotten to the bottom of the thing. She has died. There you go. So now we've got that all cleared up. We can head back to our own situation, which is bad enough as it is. There are many things that I would like to share with you today. And, there's really no plan for exactly how to go through them. More action in the Mar-a-Lago documents case these days. The government has filed its answer, is it the first answer or second answer to the activity on the motion for the special master, and apparently, by all accounts, has filed a rather imaginative, well, not imaginative, I guess, but brilliantly thought out response to the order from Judge Cannon. And let's see. I have here the Twitter thread from Terry Canefield, who I think we may have read before on the air. A former appellate defender, has some book prizes, and in the background, according to her Twitter bio, as well as analysis having appeared in the Washington Post, NBC, and others. And she begins by saying, here we have the DOJ's motion for a partial stay of Judge Cannon's order pending trial. They don't want to be enjoined from further review of the records bearing classification markings, and they don't want to give records bearing classification markings to a special master. But as you may recall, Judge Cannon did sort of bifurcate the order and say, well, the intelligence community gets to continue with its damage assessment, but I'm going to put up a halt to the criminal investigation with respect to these seized documents. So how has DOJ opted to respond? They do express some reservation, like the special master wouldn't really be the proper method for sorting out classified documents. And why? Well, there are several reasons. One, we don't know who the special master is going to be, and why would you would need to have someone who had like top secret clearance, and it's unlikely that you're going to get such a person to serve as special master. They're probably busy with something else. And so you have this problem. If you're going to give over these top secret documents to a special master, that creates a problem all by itself. Besides which, there are only a couple of questions the special master can be asked to decide. And one of them was classifying, I shouldn't use the word because it's confusing, but I guess imposing a taxonomy, let's say, upon the different types of documents that they get. Those which are classified, as in the secret classified sense of the term, those that are not, those that might be subject to executive privilege, if that can be said of any of them, and those that might be attorney-client privileged, if that can be said of any of them, and then things that are irrelevant to all such categories that might just be personality, which can be returned to Donald Trump, provided anybody thinks that he actually owns those things. And that's one problem. And the second one is, some of those things that are, how do you find out that a document is classified? Well, some of them are marked classified, and that'll help. But I guess if there's any claim that there's been documents that are declassified, or if you just need to verify, is there a document at all? Some of these folders are empty. You don't want the special master having to look at each document, especially if they're classified and they don't have the clearance to see these things. How are they going to do that job? On top of that, the job of sorting out which documents are classified from which documents are not, it doesn't really require a special master. The government is saying, well, the ones that are marked classified are classified, and the ones that are marked, top secret or top secret, whatever it is, that's classified too. And the ones that aren't are presumptively not classified. Maybe they ought to be classified, but that's not what the special master has to do. But then there's also the job, I forgot one other category, is separating out government documents from non-government documents. All the classified ones will be government documents, but not every government document will be classified. You see how that Venn diagram would have to be drawn. But it, like I said, poses a couple of difficulties, and at the same time also poses the difficulty of finding something for the special master to do when it comes to identifying whether or not a document is classified. If it says classified, it is classified. Job done. Don't really need you for that. What about attorney-client privilege? That's more complicated. You'll have to actually read the documents and get some sense of what's in them and whether anybody's claiming attorney-client privilege. And then you'll have to decide questions like, is the attorney who wrote this a U.S. government attorney representing the United States government when Donald Trump was its president? Or is this a personal attorney hired by Donald Trump to deal with personal matters for him? If he were paying his taxes, which he wasn't, perhaps an attorney advising him on tax structure and how to approach paying might be a private thing, or a sale of a condo in Trump Tower, possibly a private thing. On the other hand, very often he probably handed things that should have been handled by a private lawyer. He probably did hand to the White House counsel and say, you got to do this work for me for free. I don't want to pay a lawyer. All these lawyers that have to get paid. I've got a lawyer sitting right here already getting paid by the United States government, which is me. He would confuse that stuff all the time. Now, that could be attorney-client privileged material, except the question is, was it supposed to have been handled by a private attorney and he intentionally handed it to a public attorney, a U.S. government attorney paid for by our tax dollars because he didn't want to pay, and it really should have been handled by private and wasn't? Or another mistake, quote-unquote mistake that he frequently made was that he would say government business that is properly handled by a government lawyer, but that is personally embarrassing to me, can be hidden from the public by calling it attorney-client work product, except really the client here is the United States government and not Donald J. Trump. But he didn't care, and he'd like to claim that it was him. So there's a little bit of work to be done, yes, but no work to be done with respect to deciding which documents are considered classified. It's the ones that say classified on top. So they make a point of doing, of saying so, and saying, well, we can lighten the burden. They don't, apparently the thing that most of the analysts appreciate most about the government's answer was it was clear and decisive, but it didn't needlessly antagonize the judge by saying, well, you're a moron for not understanding what you're doing, even though you're a moron for not understanding what she's doing. Some profiles of the judge out there, too, might help clear things up. Anyway, I should read through this thread real quick and get to it. The government, as Terry Canfield puts it, doesn't want to be enjoined from further review of records bearing classification markings. They don't want to give those records to a special master. Here's the screen grab here from their motion, the United States' motion for a partial stay pending appeal. Never mind the gobbledygook at the top, the substantive stuff here. Specifically, the government seeks to stop, to the extent that the order, 1, enjoins the further review and use for criminal investigative purposes of records bearing classification markings that were recovered pursuant to a court-authorized search warrant, and 2, requires the government to disclose those classified records to a special master for review. The government respectfully requests that the court rule on this motion promptly. If the court does not grant a stay by Thursday, September 15th, the government intends to seek relief from the 11th Circuit. So there's your answer about whether or not they're going to press this in an appeal right away or wait until later. They have to have this answer, at least with respect to a stay. So they might be able to narrow it that way and still move on with the case. Second tweet in the thread here, they disagree with the entire order, but they're appealing the part that can cause actual damage to the government and the public. And they've already segregated the records. So these are they offer 3 reasons for their desired appeal. And it begins this way. Although the government respectfully disagrees with the court's injunction as to a much broader set of seized material already in the possession of the investigative team, it is not at this time seeking a stay as to the vast majority of those materials. Instead, this motion is limited to the order's directives with respect to the seized classified records, because those aspects of the order will cause the most immediate and serious harms to the government and the public. Let's see. Second screen grab here. The classified records, a discrete set of just over 100 documents, have already been segregated from the other seized records and are being maintained separately. So, there's not a great deal for the special master to do at the moment with that stuff. So, okay, moving on to the next tweet in the thread. Reason number 1. The court's decision was mostly focused on Trump's personal documents, and he can't claim he owns government documents, especially not ones marked classified. Also, documents marked classified can't be covered by any privilege. Again, the screen grab here. First, the government is likely to succeed in its appeal of the order, maybe, as it applies to classified records. It should, but you never know with these weirdo judges. Indeed, the government is likely to succeed even under the court's own reasoning, which focused principally on the plaintiff's personal documents. That's not what we're talking about mostly. She was aghast at or believed most of Trump's brief, which said that the vast majority of what was seized was personalty, and it wasn't. The strategy, Canfield tells us, just go after what matters most and what will be hardest for the courts to wiggle out of. I think it was pretty smart. Go for what you need, be reasonable, and limit the request to what is essential. Don't annoy even bad judges. Now on to reason number 2 for their appeal. Start out with a little flattery. The court was correct that a national security risk assessment was essential. Good for you. The problem is that national security risk assessments can't really be segregated from the FBI's ongoing investigation into what happened with these documents, which is kind of what I thought initially myself. This court, they write, correctly recognized the government's vital interest in conducting a national security risk assessment of the possible unauthorized disclosure of the classified records and any harm that may have resulted. The court thus stated that in its order was not intended to impede the classification review and or intelligence assessment of the ODNI, but the review and assessment on their own are not sufficient to address and fully mitigate any national security risks presented. The intelligence community's review and assessment cannot be readily segregated from the DOJ and the FBI activities in connection with the ongoing criminal investigation, and uncertainty regarding the bounds of the court's order and its implications for the activities of the FBI has caused the intelligence community, in consultation with DOJ, to pause temporarily this critically important work. So that's very interesting, too. They recognize that she recognizes that she can't really politically, not tenable, to stand in the way of the damage assessment. So they say, we're so concerned with complying with your order, because we love you, Judge, so much, that we don't want the FBI to violate the part of the order where you say they have to stop. But that has caused us to stop the damage assessment as well, and we know you didn't want that. We're going to need your help straightening this out.
Sup, fam? It's your boy Darwin, aka Darwin_Darko, aka the most reasonable man in America, aka KITM's senior black correspondent. You might remember me from such recordings as Spacemen vs. Space Cadets and We Need to Talk About Joe Biden. Today, I want to bring you good news about that thing you've been struggling with. Do you suffer from giving too much of a damn? Do you turn on the series of tubes and find yourself outraged at the particular way some news organization strung some sentences together only to realize, nope, this is not some fictional hellscape? Well, guess what? You no longer have to accept the life of giving too much of a damn. You can do something about it, because even you, yes you, can be a show contributor. Now I know what you're thinking. Hey, Mr. Most Reasonable Man in America, I'm not some professional podcast talking guy. Don't worry about it. Do you have a smartphone or some other electronic recording device? Well, that's all you need. You too can have a segment where you can read us an important article and give us your take. Read one of your own original essays, or even just give us your commentary on something you'd like to share that's important to you. Fair warning though, side effects may include general punditry, having opinions and hot takes, getting stuff off your chest, and hearing your own voice. If your recording lasts longer than 5 to 7 minutes, please consult kagrox@gmail.com. That's KAGROX@gmail.com.
All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. Okay, so we left off right in the middle of Terry Canefield's analysis of what went on yesterday. And I should remind you, and I'll bring you up to speed right after this, but though they are filing this response and asking to appeal and to look for a stay pending trial, they are also at the same time going forward on track 2 here and preparing for today's midnight deadline from Judge Cannon to go ahead with the special master process pending the outcome of their request for a stay, which was requested pending the trial. So everything's sort of moving along on its own track. So as I was saying, let's see, did we read this whole clip here? This was their claim that as much as we'd like to comply with your genius invention of this bifurcated classification review / criminal investigation into these documents and keep one separate from the other, it just can't work. And I know you very much wanted not to impede the damage assessment by the intelligence community. However, the only way that the intelligence community can comply with your order banning any further work on the criminal investigation is to stop its own work. They can't be separated. And so we could approach this in one of two ways. We can either say they can't be separated, and so therefore you definitely did want the damage assessment to go forward, so we'll go forward with that. And to the extent that that leaks into the criminal investigation and violates the judge's order, then so be it. It was a stupid order to begin with. Or the other approach could be, well, as much as she said she would get out of the way for our damage assessment, she was very clear about not allowing the criminal investigation to go forward. So anything that would further the criminal investigation at this point cannot happen. If that means it's going to block the damage assessment, then so be it. Yes, she said she would get out of the way of that one, but she was also so clear that this one couldn't happen, and we don't want to do anything that would give Trump or anybody else any opportunity to say, well, they violated the judge's order. They're not following the rules, even though this whole thing is about Trump not following the rules, and he really has no clean hands, tiny as they are. Easy to clean, but very tiny, but still non-clean nonetheless. But he would then turn and say, look, the government is violating. They're jackbooted thugs. They don't listen to anyone. They're lawless. So rather than have that happen, but also because they know exactly what this will look like. Judge, we respect you. The other guys are the ones that don't respect you. They said, well, you wanted to let the damage assessment go forward, but it just can't, not with the order the way it is. Let's either stay the order until you can think of a better, cleaner break, or let you reconsider whether or not it's really tenable to have this bifurcated process, or if you just can't come to another conclusion, or it can't happen quickly enough, or you need some help, maybe the 11th Circuit could help you work it out, is essentially what they're saying here. Finally, back to Terry's thing, because Trump doesn't own them, the classified documents, or the government documents, non-classified government documents, not his, belong to the government, because Trump doesn't own them, and because they've already been reviewed by the FBI, and because the court was going to allow the security review to continue, Trump can't claim harm. That is, he's had no damages here. The documents seized that didn't belong to him still don't belong to him. And so what's the damage here? Nothing. You don't own these things. Someone else does. We're returning them to their rightful owner. He still gets the special master, though. They're not going to object entirely to that. They do think that, I wouldn't have called for one at this point. I just don't think there's anything for them to do. But yeah, if you want to have a special master to review material that doesn't matter in this case, i.e. not classified material and not government documents. I mean, you can review the government documents, but how do you sort out what's a government document and what isn't? Well, usually if it's on letterhead from the government or is a memo that says it's from a government official or now an ex-government official possibly to another one, it's not a difficult thing to do. A Time magazine cover, fake Time magazine cover with Trump on the cover that says awesome guy, man of the year. Pretty easy to identify as non-governmental. And then if it's from the Department of Agriculture to the president, you say, government document. So anyway, you can have it, though. We won't stand in the way of the special master. The screen grab here from the motion. Third, this would be the third reason why the government thinks there ought to be a stay on Cannon's order for this weird bifurcated process. The partial stay sought here would impose no cognizable harm on plaintiff, that is, no damage to Trump here. It would not disturb the special master's review of any other records, including any personal materials or records potentially subject to attorney-client privilege. The government has already reviewed the classified records, and the court's order contemplates that it may continue to do so for certain national security purposes. So a stay would simply allow the government to continue to review and use the same records. They just said they actually couldn't. Which, again, indisputably belong to the government, not plaintiff, in its ongoing criminal investigation as well. but you should basically drop the bifurcated thing and let us do what we have to do. The point the DOJ keeps trying to make at the hearing kept trying to make at the hearing was that Trump doesn't own the government documents. Trump said, but they took my personal stuff. Well, okay, says the DOJ. You can't possibly claim personal ownership of national security documents, and possession of national security documents are what matters for charges brought under the Espionage Act, as we well know. The strategy in writing it this way was to give the court a way out, to let Trump feel like he won something and still get what's important. And then she passes on the comments of another fellow law professor, saying that she agrees with this. Peter Aranella, who says, Peter's a law professor emeritus with expertise and experience in criminal defense. It's hard to see how the court wiggles out of granting this. That said, I've seen courts make some very bad rulings. They tended not to like my clients, says Terry, pointing to, well, all Peter Aranella's comment here was exactamente, and a good strategy it is. So Terry continues on. The government confirms its plan to make available copies of all personal and not classified government records and to return the personal items that were not commingled with classified documents. Those do have evidentiary value. But let's see, how do they write this up here? The screen grab says, among other things, the government's upcoming filing will confirm that it plans to make available to plaintiff copies of all unclassified documents recovered during the search, both personal records and government records, and that the government will return plaintiff's personal items that were not commingled. Well, she just quoted that directly. Not commingled with classified records and thus are of likely diminished evidentiary value. From the discussion center, plaintiff hasn't shown that he has standing to seek relief, or that the court properly exercised jurisdiction with regard to the classified records. This is the part they're digging in on. And this is the part that would be important to defending the prerogatives of the executive branch, where they really typically refuse to bend on things like this. What's the specifics? As an initial matter, they write, plaintiff has not shown that he has standing to seek relief or that this court properly exercised its equitable jurisdiction with regard to the classified records. The classified records are government property over which the executive branch has control and in which plaintiff has no cognizable property interest. They provide their authorities here as usual. Accordingly, even if, as the court stated, plaintiff has made a colorable showing of a right to possess at least some of the seized property, sufficient to establish his standing to request that a special master review records that might potentially belong to him, he categorically cannot make that showing with respect to documents marked as classified. So, really, a special master's only possible job would be to separate those things which he, either commingled with classified documents, and that's why they ended up seizing them, or just, happened to be in other boxes that got taken by mistake or along with it, because they were piled up along with things that had nuclear-type secrets in them. And they wanted to sort the stuff out. They run through the analysis that allows for equitable jurisdiction. Never mind exactly. I don't know if I can explain exactly what that's all about, but essentially sometimes, I guess the best quick and dirty explanation for equitable jurisdiction, in this case being, by the book, it really should be something that was filed in Washington because it involves, all the classification and all the experts are up there on that, plus the Presidential Records Act, which limits jurisdiction to D.C., etc. But okay, in fairness, and that's what equitable really is getting at. If you wanted to make an argument and say, okay, the rules don't say this, but if you wanted to be fair and just and right about things, sometimes equity demands that you bend the rules a little bit. And that might be something like, the ex-president lives in Florida, the documents are in Florida, the Southern District of Florida is where they got the search warrant from. So we'll begin our proceedings here and equitably and not remove to Washington, D.C. just yet. So they run through the analysis that allows for equitable jurisdiction, but focusing on the documents marked classified, it's obviously an easy argument to make if the focus is just classified documents. The motion here reads, likewise, this court's exercise of equitable jurisdiction, which is, quote, reserved for exceptional circumstances and must be exercised with caution and restraint, cannot extend to classified records. Under Ritchie versus Smith, remember the Ritchie test? The exercise of that jurisdiction is governed by 4 factors. Here's the test. 1, whether the government has displayed a callous disregard for the constitutional rights of the subject of the search. No. 2, whether the plaintiff has an individual interest in and need for the material whose return he seeks. No. Definitely not with classified stuff. 3, whether the plaintiff would be irreparably injured by denial of return of his property. No. And 4, whether the plaintiff has an adequate remedy at law for the redress of his grievance. Yes, he does, somewhere else. None of those factors favors exercising jurisdiction as to the classified records. No reason to do that down here in Florida. Similarly, the court's reasoning with respect to the 4th factor, that without Rule 41G, plaintiff would have no legal means of seeking the return of his property for the time being, is categorically inapplicable to classified records because the plaintiff has no legal right to have those records returned to him. Such records clearly belong in government custody and, as a matter of national security, must be fully accessible to the executive branch. Accordingly, the government is likely to succeed in demonstrating that, and it goes on at this point to say that it will succeed in demonstrating that the plaintiff has no particular personal property interest in all of this, and basically that was the last thing that they could hang their hat on for keeping jurisdiction of this case. The DOJ still thinks the whole special master thing was unnecessary. That should be clear. But even by Judge Cannon's own reasoning, there is no justification for including documents marked classified in her opinion. This, she writes parenthetically, isn't an appeal, but if she denies their request, they'll appeal. So that's an interesting. We're not saying we're appealing your ruling to overturn you formally by the 11th Circuit if we can get a non-crazy panel. But we are saying we will, unless you take this opportunity to say, you know what, I've thought about this again and I'm going to stay my own order, which I can do. Basically, the DOJ is redoing its argument. Instead of talking about seized materials, they're talking about documents marked classified, a change in the terminology, which makes a difference. Because good luck trying to say that to Trump, not Biden, controls access to classified documents. And that's basically what they're saying. Look, Judge Cannon, I understand where you were coming from, but we can't make this any clearer. They're classified documents, and you're supposed to decide whether Biden, the current president, has a better claim to these things than Trump, the former president. And kind of everybody with their head on their shoulders will say, classified government documents, surely as between the two of them, the greater claim lies with the current president. But you're going to say they don't? And, unless she's really willing to do anything for Trump. This will be the answer, right? If she just says that, she'll say, I don't read it that way. I read it a different way. But that's all there is to it. Classified documents, they gotta belong, quote unquote, to somebody, and the two claimants are the current president and the former president. How are you gonna construct an argument that they belong to the former president and that they can stay with him and that the current president of the United States is not authorized to see them not because they're too classified, but because Donald Trump really likes them a lot and wants to collect them. They're tchotchkes and he just wants them. And he doesn't want the current government to know what was in these government documents. That's, going to be awfully difficult to justify. So, anyway, right. So here's another screen grab from the filing. The Supreme Court has long recognized the president's authority as head of the executive branch and as commander-in-chief, remember all that stuff, to classify and control access to information bearing on national security. Quite so. Is there a second page to it? Oh, yes. Well, I might as well read this all the way through. Citing the casework for it. All right. But generally speaking, things that you knew about the executive branch. and how it works. Here's where they say that handing over highly classified national security documents to a special master is a terrible idea. In other words, Trump should not share in the decision making of who gets to see the classified documents. The order was for a meet and confer to suggest a special master. Right, so no showing the documents yet. The government and public would be irreparably harmed, they write, by the unnecessary dissemination of classified records. Yes. Finally, the court's order would irreparably harm the government and the public by unnecessarily requiring the government to share highly classified materials with a special master. The Supreme Court, I'll just read a little bit more here, has emphasized that for reasons too obvious to call for enlarged discussion, the protection of classified information must be committed to the broad discretion of the agency responsible, and this must include broad discretion to determine who may have access to it. The court has thus recognized that the executive branch has a compelling interest in withholding national security information from unauthorized persons. Basically, like they said, yeah, duh. And the fact that this person needs to be a special master doesn't automatically create clearance. So, no, I don't think so. Here's where they cite law about irreparable harm to Trump. Of course, Trump thinks that being investigated is an irreparable harm, and that'll help clarify. If you don't understand, if they say it's so clear why he doesn't have an irreparable harm, why is that exactly? He says that he does have an irreparable harm. Well, being investigated and suffering reputational damage is not the same thing as irreparable harms. It could be considered one, but it's not a very strong interest versus, say, the government's interest in keeping classified material classified. If you weigh the two against one another, it's going to come out on the side of the government almost always, unless you're crazy, like maybe Judge Cannon's crazy. I guess we'll find out. So, but no, according to the Supreme Court, that doesn't count as irreparable harm. Although defense lawyers everywhere would like it if it was, that's true. Plaintiff's only possible, quote, injury relates to the government's investigation itself, but that injury is not legally cognizable. As the Supreme Court has made clear, the cost, anxiety, and inconvenience of having to defend against potential criminal prosecution cannot by themselves be considered irreparable in the special legal sense of the term. I mean, they do happen, and even if you defend yourself successfully, they still did happen, and if it's reputational harm or whatever that you're talking about, that can't be undone, although really acquittal goes a long way to undoing those things. So if you think you can acquit yourself, by all means, press your case. That's your opportunity for undoing the harm that you've been done. And if it's just embarrassment that having been indicted, I guess that's irreparable, but it's not what we're talking about here. We don't recognize it as the kind of thing that erases irreparable harm. By the way, with respect to irreparable harm and reputational damage, I just want to note for the record that there are two cases, at least there are a couple here, but two cases immediately cited for what I just read you, that the Supreme Court had said, no, being embarrassed by having a criminal investigation is not the kind of irreparable. If that were the case, then nobody could be arrested for anything. You could always say, hey, I did rob the bank, but the irreparable harm to me that would result from being brought to trial for it is enough to stop you from bringing me to trial. Nothing would work. That case that they are quoting here is actually Younger v. Harris, a 1971 case, and you are to see for comparison a case that I guess contemplated some of this, the quote here is, bearing the discomfiture and cost of a prosecution for crime, even by an innocent person, is one of the painful obligations of citizenship. Yes, sorry, it is true that you could be embarrassed and nothing will erase the embarrassment, although you can, win absolution for yourself in court, and that will mitigate the damage. Sorry, but being a member of society and a citizen of the country means, you'll have to defend yourself if you are brought up on charges that there's reasonable cause to believe you should be tried for. That's just one of the irreparable harms you're going to have to live with, and acquittal is your best bet. But it's how do you know that the court is not worried about embarrassment for people like this? And this is where I've been going for the last minute. The name of that case, I don't know whether this was a state charge, a federal charge, who the other party was to this. They only name the one party by which the case is known. And although I don't know the case, I presume that people who hear the name of the case will remember it right away, not just because it's such a memorable case and the eloquence of the writing, bearing the discomfiture of the cost of prosecution for a crime. Probably only part of the reason why they remember the case titled Cobbledick. There you go. So poor Mr. Ms. Cobbledick has, to come to the United States Supreme Court by the name of Cobbledick and to say the irreparable harm that I have to face here is the reputational damage and the embarrassment at appearing in society. Well, that kind of thing gets taken care of at the magistrate level if you want to change your name. No, it was the charge brought against me that was embarrassing, not the fact that my name is Cobbledick and I am stuck with it. And I have apparently made no effort to change that. I think that's somebody with thick skin. I don't know that many thin-skinned Cobbledicks, but I don't know any. But that's a hell of an insult. And so from now on, ladies and gentlemen, you ought to keep that in your pocket and say to somebody, well, you thin-skinned Cobbledick, I can't believe you would do such a thing. You're right. Well, there are other cases that bear on this, just so that we know and give full credit to the writers of the motion here. That is why courts have exercised great caution before interfering through civil actions with criminal investigations or pending cases. You can see for more information about that, Deaver versus Seymour, nobody funny related in that one, or Ramsden versus United States. So anyway, nothing beats Cobbledick if you ask me. Anyway, yes, Terry concludes here. I think, we're getting towards the end here. Yes, and this down below sets them up for an easier argument to make on appeal if the judge insists on including the classified documents in her order. It's much cleaner to make the argument regarding the documents marked classified. Someone was asking here, can Donald Trump appeal if the judge allows this? Yes, of course he can, but it sets them up for an easier argument if she insists, the judge insists on including classified documents in this order blocking the investigation. And Terry goes on, I have a silly mistake in the very first tweet, but don't worry, I won't delete it and start over. Should have been a partial stay pending appeal, which makes sense. When I make a silly mistake, it's always in the first tweet. Never mind that. I think we figured that out. A bit more into the weeds. Yay! We get some hints about the empty folders and the importance of the ongoing investigation. This was from the section on why the government can't segregate the national security investigation from the criminal investigation. They write, the FBI would be chiefly responsible for investigating what materials may have once been stored in these folders and whether they may have been lost or compromised. Steps that, again, may require the use of grand jury subpoenas, search warrants, and other criminal investigative tools, and could lead to evidence that would also be highly relevant to advancing the criminal investigation, even though they would be all about the damage assessment. It's just, it can't be mingled, or it can be disentangled, I guess I should say. There are hints throughout that there may be more that they don't know yet about what Trump has done with these and other classified documents, which explains why they are not yet ready to indict. And then Terry concludes by saying, I just read this thread and I was sort of unclear about the procedures. They are asking for a stay pending appeal. If she doesn't grant it, they'll probably ask the appellate court to offer a stay pending appeal. And if they get that, that's all that really matters. So, okay, what about this judge, by the way? I happened across this thread that somebody else who had retweeted it into my timeline said, this is really rather stunning. I'm sure, pointed and somewhat partisan profile of the judge, Eileen Cannon. Peter Vroom, who writes this, is, founder of Stand for Democracy. Congressional Chief of Staff in the past, House Oversight Committee staff, NRCC campaign director. Oh, interesting. So a former Republican. He lists himself as a former Republican. Peter Vroom, who ought to go into the motor industry, if you ask me. And I know I have a partner for you here. If you want to start a law firm, Vroom and Cobbledick. You want to try that one? Anyway, Eileen Cannon, a 38-year-old lawyer with no judicial experience, but, she's been put in at the district judge level, or typically they have some, whatever. But anyway, I guess you got to start somewhere. So, all right, she's at the lowest level of the federal bench, so maybe that's not so unusual they wouldn't have experience yet. But no judicial experience and a limited resume, was just handed a lifetime appointment as a federal judge just as Trump left office. This is actually a tweet thread from back. It's contemporaneous. After all, it's current. The writing made it sound like he put this thread together when she was initially confirmed. But anyway, relatively speaking, just confirmed to lifetime office because it happened after Trump was defeated. So Cannon's primary credentials, he says, for the job were apparently her, one, young age, and that way she lives forever and is making decisions that are pro-Trump and pro-conservative for many, many years. You understand that. And, of course, membership in the Federalist Society, which, I got to tell you, my impression of the Federalist Society, it's changed over the years, but when I was in law school, it was just, there was a flyer up on the board along with everything else, like joining any club. Join the Federalist Society. It's about, law stuff. We have drinks. Come on over. So sometimes people's initial involvement with the Federalist Society doesn't amount to much. But, if you end up owing your jobs in the future to Federalist Society referrals, you might take it more seriously. Anyway, her professional experience, it says here, was so limited that she was forced to admit on her Senate Judiciary Committee questionnaire that she had never made any speeches, produced any reports, participated in any panel discussions, spoke at any conferences, or written for any bar association. So that's kind of interesting all by itself. You might say, well, of course she doesn't have any judicial experience. This is sort of an entry-level judicial job, and it really is not an entry level, but sometimes people will be state court judges and come to the notice of the Republican apparatus and you get bumped up to the federal bench or whatever, or you've been a clerk for an important judge or even a Supreme Court justice. But if not, then certainly you've made your bones and risen to notice by being an important speaker and an important thinker, somebody recognized to speak at all these panels. No, she's just there and willing to say the things that she's supposed to say. So poof, you're a judge. Welcome back now, finally, to the Kagro in the Morning Show. You know where you are. I had to press the unmute button about 100 times, and then, once you do it once and it doesn't unmute, then you get nervous about, am I pressing it right, wrong? And you start pressing it more carefully, and things just get worse from there. Anyway, we left off, we were in Peter Vroom's thread about the mysterious Judge Cannon and kind of where she came from. And, that's pretty blank as far as a resume goes. Not only no judicial experience, but tell us about some of the other things that, in the absence, as frequently happens with judges appointed to the district courts, the trial court bench. What do you have besides judicial experience that would make us think that you are an important enough thinker to get a place on the federal bench? Are you a ghost hunter, perhaps, or anything like that, like the other guy? I think he withdrew his application. Anyway, but there was nothing. And here's I guess the screen grab of her questionnaire. Supply 4 copies. They ask, give us your background, right? Supply 4 copies of any reports, memoranda, or policy statements that you prepared or contributed in the preparation on behalf of any bar association, committee, conference, or organization of which you are a member. If you do not have a copy of a report, memorandum, or a policy statement, give the name and address of the organization that issued it, the date of the document, and a summary of its subject matter. Answer: none. Well, how about this? Supply some copies of any testimony or official statements or other communications relating in whole or in part to matters of public policy or legal interpretation that you have issued or provided, or that others presented on your behalf to public bodies or public officials. Do you have what it takes to be, are you the kind of thinking person that, despite having no judicial experience, might make a good judge because you've thought about the law a lot and you've had important thoughts on it and you've shared them with people? No, I am not. Oh, okay. Well, maybe you could supply copies of transcripts or recordings of all speeches or talks delivered by you, including commencement speeches, remarks, lectures, panel discussions, conferences, political speeches, and question and answer sessions. Include the date and place where they were delivered and readily available press reports about the speech or talk. If you don't have a copy, how about, again, giving us the name or address of the group before whom the speech was given and the date and a summary of the subject matter. And if you didn't speak from a prepared text, maybe furnish a copy of any outline or notes from which you spoke. Answer: none. That's fairly unusual, I would think. I don't know whether she got a qualified rating or not. That's a good question. Anyway, in her 12 years as a lawyer, she is a lawyer, she published no writings of her own, just 3 writings done with colleagues at the firm that she worked at, Gibson Dunn, limited to promotional articles on cases handled by the firm for their own website. That's really not a whole lot. Here, list the titles, publishers, and dates of books, articles, reports, letters to the editor, editorial pieces, or any other published material you've written or edited, including material published only on the internet. Let's see. So here with John Stirk, David Burns, John Chesley, Gibson Dunn persuades SEC to dismiss proceedings against former general counsel of Ferris Baker Watts. In other words, a press release on the Gibson Dunn website with 1, 2, 3 other authors. Another press release. Gibson Dunn wins unanimous dismissal of fraud charges in auction rate securities case, also on their website. And again, with 2 or 3 other people, another press release. Gibson Dunn secures significant dismissal in litigated SEC administrative proceedings. This is not like legal thought. This is PR material. In an attempt to show writing experience, Cannon listed 17 short articles from a 2-month undergrad stint at El Nuevo Herald, Spanish language newspaper, ranging from prenatal yoga to flamenco, an explosion of energy and passion. Cannon is unclear on whether she authored or simply edited those articles. She's not entirely sure. 2 months as an undergrad, Spanish language newspaper covering prenatal yoga, etc. Not sure if I really wrote it or not. Those are her writings. Wow. Not a lot. Finally, the questionnaire for a lifetime judicial appointment asks Cannon to list all interviews that she has given to the media. Cannon lists only her wedding article in the local magazine as her only media experience. How do you like that? That's a nice one. So list all interviews you've given to newspapers, magazines, or other publications or radio and television stations, providing the dates of these interviews, etc., etc. And here's the one. Caitlin Moscatello, Eileen and Josh, a traditional wedding in Coconut Grove. That's a hell of a piece. So, somebody else asks, is she a citizen? Yes. How did she get into the Federalist Society? And that's a good question, just, again, to kind of tell people what it's really all about. And Peter answers quite honestly, it's awfully easy. A lawyer simply pays the $50 annual membership fee. Here's Cannon's response to Senator Feinstein on why she joined the Federalist Society in law school 3 years before she became a lawyer. Many conservative lawyers joined to establish their conservative bona fides, as Armando likes to pronounce it. But this is the reality of how you often enter the Federalist Society. And maybe it was weird or different from where I went, because of where I went to school, which was at what was then the George Mason University School of Law, now the Antonin Scalia George Mason blah, 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 University, School of Law. And so maybe that was uniquely infested with Federalist Society people, and it was too easy to trip and fall into the Federalist Society. But here's the question posed by the senator. When you joined the Federalist Society in 2005, 3 years before you began practicing law, did you believe it would help your chances of being nominated to a position within the federal judiciary? Please answer yes or no. No, was her answer. If your answer is no, then why did you decide to join the Federalist Society in 2005, 3 years before you began practicing law? I would say to that, before I even read her answer, Because I guess I would know what the answer is going to be. You could have asked me the same question. I did not join, but I could have. I mean, it was right there, and I contemplated it, because at the time, and this for me was even earlier, but this is 2005 for her, this would have been 1995 or so, that I would have seen a flyer like join the Federalist Society. I was like, I don't know. So what do? I got to go to a meeting. Oh, right. I'm a night student. Gosh, I can't make it to this meeting. So no, I guess I just won't. And besides which, what the hell is the Federalist Society? I don't know. Nobody knew what it was. And the answer before I even read her answer, I would say it's an unfair question, really. It's asked from a weird perspective, and not incorrect perspective, but now we know an awful lot about what the Federalist Society has been up to and what they've been doing. But I've always been a little bit skeptical of it. But there's parts of the operation which are far, far removed from what the average typical law school student would be exposed to. All the things that Leonard Leo is up to. And I'm being urged daily in the KITM hashtag timeline here to discuss this. Rebecca Romans keeps sending things. Sheldon Whitehouse calling out Leonard Leo. And it's all good material and definitely deserves to be gone over. But I mean, we need like a week to do the Leonard Leo thing again, which we did once already. But that's not the experience that the law school students are being put to. And so here, why did you decide to join the Federalist Society in 2005, 3 years before you began practicing law? Well, I was offered the opportunity to join the Federalist Society 4 years before I began practicing law. But of course, I never did practice law, so I guess that doesn't really count for me. But had I begun practicing, it would have been 4 years, because I went as a night school student, and it takes 4 years to get through law school at night, not just 3 if you go full time. And the answer is because there was a flyer on a bulletin board that said, come see what we're all about, and we'll have pizza and maybe beer. And that's why I went, to go see if maybe this was a thing that I could join. And they said, yeah, we mostly do, we bring speakers in and whatever. And at that level, that's all it is for a college student. If the Federalist Society isn't a job-seeking program, or certainly wasn't in 1995, it was like, and there was no hint whatsoever, we can help get you jobs in the federal judiciary. No, it was a pizza and beer and study group kind of thing. And we bring in speakers from time to time. And if you pay the $50, you get to have the beer and the pizza, and we can pay some honoraria to our speakers. And, maybe it'll be a judge here and there, or somebody of importance, a writer, yada, yada. It was never like, pay the $50 and we'll make you a federal judge. No. What does she say? I joined the Federalist Society in 2005 as a law student at the University of Michigan Law School. I did so because I enjoyed the diversity of legal viewpoints discussed at Federalist Society meetings and events. And that's prettied up. I also found interesting the organization's discussions about the constitutional separation of powers, the rule of law, and the limited role of the judiciary to say what the law is, not to make the law. I mean, that's an incredible description of the importance of the Federalist Society to a law school student. I mean, really, I joined because, I don't know, it was an activity. I recognized the name. It sounded like something, I want to have activities on my resume so that when I get it, I can get some kind of job. They have pizza and snacks at their events. They occasionally bring in lawyers or writers or judges of importance, so you meet them and hear about stuff, and I'm a student. But they make it sound like you joined 3 years before you began practicing law. When you're in law school, it's just an activity there. Like, why did you join the 4-H club 4 years before you became a farmer? Yeah, well, it was there, and I was interested. It is kind of an accusatory tone to a dumb question. Anyway, I think that actually, now we're now into the comments on the Peter Vroom thread. But that was an interesting opportunity to clear something up about the Federalist Society. It's not for law students. It's not like a nefarious secret society it's not Skull and Bones or something that you join with the hopes of climbing into the federal judiciary. It's just a thing. They have speakers. And you go, your friends are in it. It's an activity. Why did you join Spanish Club? I wanted to take over Latin America? No, it was just a club. I just joined it. I can defend her on those grounds. So you can't say I'm hopelessly biased against Judge Eileen Cannon, can you? I offered some support. All right, on to other issues or maybe even other angles on the same issues. Again, I have no way of getting to all of these things here. So I'll give you what we can give you and cry about it at the end. How about this? This was an interesting idea that I think I saw circulated. Oh, I couldn't remember exactly who was circulating this thing, but here's a piece from Inquest, which is inquest.org, which just, I guess, here in the little, I don't know what you would call this here, but in the header here, not the headline, but the banner, the masthead, Inquest is describes itself as a decarceral brainstorm. That'll give you some idea of where we're coming from. And an interesting piece here from Peter N. Salib and Guha Krishnamurthy, nullifying, we're not for nullification, right? Nullifying Dobbs. Oh, I might be for nullifying that. Read on. Jurors' conscientious refusal to convict people charged for violating abortion bans is perfectly legal and what justice demands. Ooh, radical. Let's read on. Okay. The state of play for abortion rights should be well known by now. It is, you know it. The Supreme Court of the United States has overruled Roe v. Wade, ending any recognition of a constitutional right to terminate a pregnancy. Several Republican-led states prepared in advance for this outcome, passing trigger laws that would make abortion illegal upon Roe's demise. Other states have acted quickly since the court's decision, making abortion a criminal offense. Others will soon follow. Many of those laws are draconian. Some ban abortion very early in pregnancy, sometimes from the outset. Some lack exceptions for rape, for incest, or for serious danger to the mother. The laws are also unpopular, as the politics of abortion are beginning to show. In recent weeks, reliably red Kansas voted in double digits against amending its state constitution to allow for criminal bans on abortion. Under conditions like these, we have recently argued a legal venue called jury nullification, usually associated with real nefarious causes, let's say. Also known as conscientious acquittals, I guess on the brighter side of things, where they say this person has been unfairly charged with a crime that technically applies, but in equity ought not to. But yet we're here and we'll exercise our role as jurors to simply say we refuse to apply the criminal law to this person. So, also known as conscientious acquittals, may have a role to play in securing reproductive rights. It's just scary to have to depend on it and doesn't always work. Nullification occurs when a legal decision maker refuses to convict the defendant despite factual evidence of the defendant's guilt. The most common version of jury nullification, wherein at least some jurors take this approach. Consider a recent real-life example. In 2019, federal authorities in Arizona prosecuted Scott Warren, a humanitarian aid worker, under a law forbidding the harboring of border crossing migrants in the Arizona desert. You know, I don't know if this is the guy that actually did this, but it was, they made it illegal in Arizona to leave water out in the desert for migrants who would otherwise die from dehydration in crossing the border. You're aiding and abetting this criminal activity of their crossing the border. Yes, but it's a humanitarian relief thing. Well, we're going to make it illegal. And I guess in that case, the jury said, yes, the law does say this. We just think it's a dumb law and unfair to prosecute and punish this person who is just about saving lives. If you want to prosecute them for their illegal crossing, fine. They're alive for you to do it. It's actually a good thing. We won't convict him. The worry about jury nullification, of course, comes when it's stuff like, well, Trump has these documents. It's very clearly not authorized that he do so, and he does have them, and it's a violation of the Espionage Act, and he should be locked up. And you find out that one of the jurors was a MAGA nut, and he just says, I don't care what the evidence says, I'm voting no. And if you are in one of those states where you need a unanimous jury for a conviction, then there's an acquittal. That's a bad kind of jury nullification. Okay. Or maybe neutrally the same. It's exactly the same physically how it works. So anyway, yes, back to the Arizona case. There was no serious dispute that Warren had done exactly what the law prohibited by sheltering and providing them with water, yet the jury acquitted, presumably after coming to the conclusion that Warren's actions, though illegal, were not unjust or deserving of punishment. Most scholars regard jury nullification as a rare phenomenon in that it seldom happens. The law imposes barriers against it, which is why you shouldn't be depending on it for protection of actual rights. But as a last-ditch effort, sure. Courts often forbid lawyers to inform jurors about their ability to nullify. They instruct jurors that their duty is to follow the law, regardless of their own moral commitments. And if a juror indicates that they plan to nullify, that juror is usually dismissed from service. Moreover, jurors might not want to nullify in many cases, even if they knew they could. Despite growing interest in criminal reform, most criminal prohibitions and criminal penalties remain quite popular. Nearly all drug prohibitions, for example, enjoy supermajority support. Yet in prosecutions brought under this harsh new crop of abortion laws, we think nullification may have a larger role to play. Consider first, the nullification only requires one juror to hold out. Criminal convictions must be unanimous, as the Supreme Court recently held in Ramos v. Louisiana. So I guess they all have to do that now. I guess people experimented with it before, and now it's no longer the case thanks to Ramos versus Louisiana. Thus, if even a single juror refuses to convict because they believe the law, as applied in the case before them, is unjust, nullification has occurred. Recent polling suggests that for many abortion prosecutions, such jurors would be common. The Pew Research Center has recently found that 62% of Americans think abortion should be legal in most or all cases. A full 90% of them think that abortion should be legal in at least some circumstances, and a large supermajority of Americans treats abortion as legitimate under the particular set of circumstances in which it's usually sought. Thus, for a large portion of the cases that could be brought under these new laws, prosecutors may have trouble assembling a group of jurors willing to unanimously convict. Texas's new criminal ban on abortions, which automatically took effect 30 days after the judgment issued in the Supreme Court's decision overturning Roe, offers a case study. This is a near total ban on abortions that criminalizes providers without exception for early term procedures, rape, incest, or fetal defects. The law's exception for the health of the mother is quite narrow, applying only when the mother would otherwise die or have a, quote, major bodily function seriously impaired. And the penalties are harsh. The maximum prison sentence is life imprisonment. How likely is Texas to be able to find jurors to convict under such a law? In the vast majority of possible prosecutions, it may be difficult. Over 90% of abortions take place within the first 13 weeks of pregnancy. Over 40% of Americans, and thus of potential jurors, think that early-stage abortion should always be allowed, no matter the other facts. So 40% of your jury pool already won't help you. When extenuating circumstances like rape, serious fetal defect, or serious maternal health risk, nearly all potential jurors think that abortion should be an option. With numbers like these, the probability of a given jury ending up containing a potential nullifier, and again, it only takes one, is substantial. The possibility of nullification here is serious enough that it might in fact be exactly that, the possibility and not actual nullifications, that matters the most. Prosecutors want to win their cases, and they adjust their strategies accordingly. The common approach to maximizing win rates is choosing to bring only cases with very strong factual records. But for abortion cases, prosecutors will have to consider not only the facts, but also potential jurors' views about what is just. This may end up dramatically shaping the slate of cases that prosecutors choose to bring. Given the above polling figures, bringing criminal charges for aborting an early-stage pregnancy of a fetus with a deadly genetic disease, say, would be unwise. So, too, for an abortion that was necessary to allow the mother to be treated for a serious but likely non-fatal cancer, let's say, discovered during her pregnancy. Even prosecutions of abortions performed for family planning reasons may be difficult to win if they were performed relatively early in the pregnancy. This is not to say that no prosecutions will be brought. They've already been brought. Indeed, prosecutors in red states might bring precisely the kind of hard-to-win cases just described due to political pressure. Consider the recent case in the aftermath of Dobbs of a 10-year-old girl from Ohio who, you've heard the story, was raped and consequently impregnated. Ohio had passed a fetal heartbeat law in 2019 that took effect after Dobbs. The 10-year-old girl was adjudged to be 6 weeks and 3 days pregnant. And as a result, the 10-year-old girl was unable to obtain abortion health care in Ohio. She then obtained an abortion in Indiana, where abortion restrictions had not yet taken effect. Thereafter, the Indiana Attorney General publicly stated that the doctor who provided the abortion to the 10-year-old victim failed to comply with the reporting laws and opened an investigation. He further mused that he could charge the doctor for intentionally failing to report such a case and look at her licensure. It's precisely in such extreme, shameful cases where we envision jury nullification serving as a check on radical political actors. Indeed, these cases may not be so rare. According to a report by the Guttmacher Institute, which the New York Times cited in connection to the Ohio case, in 2013, more than 7,000 girls aged 14 or younger were pregnant, and about half terminated those pregnancies through abortion. Thus, we expect the effect of nullification on abortion prosecutions to be twofold. First, it will reduce the range of cases that will be brought. Prosecutors fearing the possibility of objectors on the jury will avoid bringing the most unpopular charges. And second, when instances where prosecutors do bring charges, nullification may change the outcome of some cases. This becomes more likely as criminal penalties become more obviously unjust. There is some evidence beyond idle speculation of the above potential for nullification. Marijuana prosecutions are a relevant precedent. Jeez, I haven't got any of that sentence correct. In roughly the past decade, public support for the criminal prohibition of marijuana has cratered, dropping by nearly half. Today, only about a third of Americans approve of such laws. Over the same period, federal prosecutions of marijuana cases likewise collapsed, dropping by over 86%. We think that this was not a coincidence. As with abortions, most of the possible prosecutions for marijuana possession simply became extremely unpopular. Perhaps understanding this, prosecutors chose to devote their resources elsewhere rather than risk losing factually solid cases because of the jury's hostility to the law itself. Our picture of jury nullification depends on jurors' willingness to nullify, and thus, to some extent, on their understanding that they can do so. It is thus worth stating the facts here. Nullification is not a crime. It is not a civil offense. There is no punishment or penalty for nullifying. On the contrary, the jury's power to refuse conviction when justice so demands is arguably what gives the jury system its moral force. Via this power, juries act as a popular check by ordinary citizens against the carceral power of the government. And that's an interesting and important thing to do. I have actually thought about this in the tort reform context. That was, you might remember that as like the catchphrase, one of the Republican catchphrases of the 1990s, and the Newt Gingrich Republican Revolution contract with America, yada, yada. There was going to be tort reform. That is caps on damages awarded by juries because somebody blew up the story about the lady that spilled McDonald's coffee on herself, and then therefore the whole thing, the whole jury system, gigantic part of our constitutional system of government, and the one thing that's still left directly in the hands of ordinary citizens to decide, the one check and balance that our Constitution actually left with us. The Republican Party platform was convincing people in the name of freedom and the American way to give that up. Less power for you, the person, and more power for the corporate plaintiffs or defendants in lawsuits, etc., etc. So I thought that was kind of weird. The one thing that was left in our hands, they didn't trust people to wield that power. And so here is another example. Nullification, though, it should be noted, cannot and will not fix everything. Nullification itself comes at the end of the criminal process. The stress, anxiety, and fear, and reputational damage, as Donald Trump would remind you, of the criminal process can be overwhelming for defendants. And therefore, whatever. But I'm running out of time here at the end of this segment. But the stress and anxiety and fear of the criminal process can be overwhelming for defendants, and the consequences of being investigated and prosecuted, such as stigmatization and financial stress, can be devastating. No doubt about that. They're quite right about that. In some instances, thus, prosecutors may bring charges despite the potential for nullification, precisely to send a message through the harsh criminal process. But we think that equilibrium effects of nullification will be to reduce the number of cases prosecutors bring, and when unpopular cases are brought, nullification can avert the harshest part of the criminal process, the punishment. There is a bit more. I can't fit it in the next 10 seconds. Maybe we will conclude after we return from this, and then on to other stuff for our last segment. Hi, it's me, David Waldman, the same guy who was just talking to you a second ago. Our Patreon subscription drive is still going strong, with over 175 monthly donors who help keep us on the air. If we've helped keep you going during the pandemic, why not return the favor and help us keep going so we can all be together for the next disaster? Patreon.com, Patreon.com, makes it easy to make secure, recurring monthly contributions to support our show. Patreon.com/KagroX gets you straight to our donation page. Maybe you'd like to thank us for keeping you sane during the Trump era. Maybe you're looking forward to in-depth explanations of what's going on in the Biden administration. Whatever it is that keeps you listening, we need your help to keep bringing it to you. And hey, if you happen to prefer using PayPal or even the Square Cash app, we're up and running with those options too. Thanks again, everyone, for all your support. We literally could not do this without you. All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. All right, let's see. Let's continue on. We almost got to the end of the nullifying Dobbs article, which is, I think, important and interesting and pretty well written. So let's conclude here. Where do we leave off with this? Yes, right. Pardon me. The authors remind us that it's not a particularly defendant-friendly thing to do necessarily to rely on nullification. You have to go through all the stress and expense and stigmatization of arrest and possibly arrest, but certainly indictment and trial, and then roll the dice. And it all comes down to waiting for the jury foreman to stand and stand and read the indictment. Did it work? And, if it didn't, you're going to prison. Not really a great way of handling these things. Additionally, though, abortion providers are not exactly like marijuana dealers. Their identities are publicly known, making them easier targets for multiple prosecutions. If that's the, worst part of it. Then, of course, there's protest and threats to your life, etc. But as I was saying, they're publicly known, making them easier targets for multiple prosecutions, and that's just the legal side. And they are more risk averse, likely to simply close down rather than face the possibility of criminal penalties. Moreover, in some states, including Texas, they have enacted civil as well as criminal penalties for abortion because civil cases can be decided by a judge via a mechanism called summary judgment that bypasses the jury, or in some states, I guess, it still may be the case that you don't need a unanimous jury for deciding a civil case. I don't know. At any rate, the prospect of nullification may carry less weight with them. Consequently, both providers of abortion and women who seek them still face real risks. Nevertheless, nullification might change the outcomes in a variety of cases. Here are two more contexts where we think nullification could matter. First, in murky cases, nullification might tip the scales in favor of abortion providers. Consider a state that forbids abortions only after a fetal heartbeat is detected. This raises the possibility of evasion by providers for relatively early term procedures. They may simply not try very hard to detect the heartbeat. If faced with the prospect of a very anti-abortion jury, the provider might not risk the gamble of muddying the waters but the probability of nullification might be just enough to make tactics seem sufficiently safe to try. Second, as others have observed, some states may attempt to criminalize abortions occurring, in full or in part, outside their borders. That's in the offing, yes. They may punish their own citizens for traveling out of state to get an abortion or for ordering medical abortifacients from states that will send them across state lines. They might go so far as punishing anyone who even supports such acts, including by paying for them. Some Texas legislators have already threatened as much. 11 of them recently sent a letter to the Dallas office of the law firm Sidley Austin, threatening, quote, consequences for, including criminal liability, for reimbursing travel for employees seeking abortions outside the state. Actors like these, women seeking abortions in other states, out-of-state activists supporting them, global employers seeking top talent, may not be as risk-averse as in-state abortion providers, and insofar as they are willing to risk the ire of Republican legislators, nullification may offer some protection. Nullification is, at best, a shield against the most outrageous state actions, a way for the community to stand in the way of punishment. The case of abortion is no different. Yet in this arena, unlike in other arenas of criminal law, state lawmakers seem committed to outrageous acts, as evaluated by the standards of ordinary Americans. Here, then, nullification may make a difference, at least until law moderates to reflect the values of the governed. This is some big political science type concepts, I think. So, I think welcome and, at home here on the show, especially for a Friday. So, all right. I just wanted to do that. And so now the challenge is, how do you make enough people aware of the facts of jury nullification, that it can be done, that it's not illegal, you don't risk anything for participating in it if you happen to land on a jury, given that lawyers are, generally speaking, prohibited from raising the possibility in many instances in the courtroom. And that's really, that's the point of sale there, where you have to sell it to the jury. A more generalized dissemination of the information is just not going to really sink in. Well, I better listen to this in case I ever end up on a jury. People are going to do everything they can to avoid landing on a jury. So I don't know. But the only way to do it, I guess, is to do things like this. Write articles like this, read it, talk about it. I guess you could try and find some way of working it into popular culture. If they put it in a ripped from the headlines Law and Order episode or something like that, people will come to realize these things. Anyway, important thing, and part of the reason why I wanted to share it with you. So let's see, other things that need to happen and be discussed here. Gosh, there's a lot, and we're never going to get to all of them. What do we maybe want to throw in there? Okay, let's see. How about this seemed interesting. Maybe this is a good Friday piece. Something from the lost world of the pandemic. Remember that thing? Greg's not even here, but I'm still going to tell you about this. Been some interesting developments there, including, I think I put this aside too. Maybe I got to go back into Pocket and look for this, but it looked like somebody had done a study in the last couple of days. I had discussed the study in the last couple of days, about the global impact. Here it is, from, the Journal of the American Medical Association, JAMA Network. I'll give you the basic title and abstract of the thing. And this one's for all the people not listening to the show who ran around for the first couple months of the pandemic saying it doesn't affect kids, so why not open the schools? Well, there are a lot of ways to affect kids with this pandemic, and this one, a research letter published in the JAMA Network here, JAMA Pediatrics, runs under this title: Orphanhood and caregiver loss among children based on new global excess COVID-19 death estimates. In other words, yeah, it might not affect children in exactly the same way, although it turns out that it affected plenty of them, as it happens with the regular effects of COVID-19. But okay, what about the kids who lost a parent or even both parents? You certainly read plenty of stories about it, to the COVID pandemic. Well, the availability of new excess mortality data enables us, the authors here, Susan Hills, Joel Pascal Ntwali Nkonzi, wow, and William Misimburi, if I'm pronouncing correctly. The availability of new excess mortality data enables them to update global minimum estimates of COVID-19 orphanhood and caregiver death among children. And this is the entire world, not just the United States, but still. Consequences for children, of course, can be devastating, including institutionalization, abuse, traumatic grief, mental health problems, adolescent pregnancy, poor educational outcomes, and chronic and infectious diseases. Global totals and country comparisons were previously hampered by inconsistencies in COVID-19 testing and incomplete death reporting. The new orphanhood estimates derived here based on excess deaths provide a comprehensive measure of COVID-19's long-term impact on orphanhood and caregiver loss. They discuss, of course, their methodology, which will be important to those of you who read these things because you're doctors, but the results are what we're interested in here for this show. Using World Health Organization excess mortality, which is more conservative than findings from other sources, IHME and The Economist, for instance, we estimate that 10,500,000 children lost parents or caregivers, and 7,500,000 children experienced COVID-19 associated orphanhood through May 1st, 2022. Greater numbers affected by orphanhood by primary care and or secondary caregiver loss were found in the African region and in Southeast Asia, compared with, say, the Americas, Eastern Mediterranean, Europe, and the Western Pacific. But basically, yeah, that's the upshot of it. 10.5 million children lost parents, one or the other, or caregivers to COVID-19. But it doesn't impact kids. Just wanted to bring that up. And I'll share the reference with you. I guess I'll do that directly today because I think Scott's out today. So look for me to stumble my way through this thing. The other thing I wanted to bring to your attention with regard to the pandemic is from the Washington Post. Even moved to the background, pandemic deaths are shaped by politics. You all remember Charles Geba's work on figuring out whether COVID-19 deaths were significantly higher in red counties than blue, and in red states rather than blue, but down at the county levels where it would really matter, and found that, oh my, yes, it's true. Even now in this late stage of the pandemic where everybody is deciding, masks can be optional, let's all go back to school and do things as we head into flu season as though nothing were happening, even though we know Omicron isn't really covered by the vaccines we gave everybody, and we're only just starting with the new Omicron ready vaccines. But here we go. The death toll in red counties in 2022 has been 40% higher when adjusted for population. Philip Bump behind the analysis here. About every 3 minutes last month, an American died of the coronavirus. It's still happening. Even though the death numbers are way down, it's still happening. I keep showing you every night that they mount. We're over 1 million, and we'll be breaking 1,075,000 today, I'm sure, which means we'll get around to our first 100,000 past the million mark pretty soon. And remember when 100,000 deaths was an incalculable loss? Yeah. And I mentioned to you the other day, we finally did cross that threshold. 200,000 people, double the incalculable loss, have died just since the Supreme Court struck down the vaccine mandates that Alito didn't want to be blamed for. Oh, well, just letting you know. But back to Philip Bump here. Compared to other months during the 2-year period, that toll, one every 3 minutes or so, is comparably mild. In January, for example, this year, 2022, January, there was a death from COVID-19 in the United States more than once a minute. but August was worse than June, for example. So far this year, more than 250,000 people have died of the disease, a toll far larger than even a bad flu season. Remember when I used to make that comparison? Though much of the country clearly considers the pandemic over. And, as has obviously been the case, deaths from the coronavirus are inextricably linked to politics. A lengthy report at ProPublica elevates the specific example of how politics affected the response to the virus. It explores the situation at a hospital in Montana where Republican leadership blocked vaccine mandates even for healthcare workers. Governor Greg Gianforte, who punches people, elected in November 2020, quickly enacted policies aimed at minimizing the perception of the danger posed by the virus upon taking office. The article is a grim portrait of how the hospital was forced to scramble to care for sick and dying patients, even as political leaders scored points with ostentatious opposition to efforts to treat the pandemic seriously. It's a snapshot of a divergence along political lines that is pervasive nationally even today. And don't forget the example of Iowa that I brought up the other day when Joni Ernst made her comments about, oh my God, the fentanyl crossing the border, but not actually crossing. Did I bring it up on the show that she was complaining, doing the same weird thing where Republicans keep saying, oh my God, so much fentanyl was stopped at the border? And like, yeah, that's what's supposed to happen. But yeah, by the way, you don't have to imagine, because she said, enough fentanyl was stopped at the border. Weird. That to kill every man, woman, and child in the United States of America. I don't remember what the exaggerated claim she made was, but that was it. But I was saying, why imagine that stuff when you could talk about what actually happened in reality, where 1/3 of if we transferred all American deaths to Iowa, I know that's a weird statistical thing to think about, but enough Americans died from COVID for real, and you guys took this to be a joke from day one. Enough Americans have died from COVID to have wiped out the equivalent of 1/3 of the entire population of Iowa. And by the way, the population of Iowa, like the population of the United States, is very unevenly distributed. There's a lot of empty Iowa. But as we know from the popularity, unfortunately, the lingering popularity of the Iowa caucuses, Iowa has 99 counties, very famously. And political candidates have made a thing of visiting everyone. I think that was at least a Rick Santorum thing. I've been to every one of the 99 counties. Doesn't make any sense, but I've been there. Well, some of them are very low population counties. I think some of the smaller ones are like in the neighborhood of 3,500 people in the whole county. If you start from the bottom of the list and work your way up towards the most populous counties, the death toll from COVID-19 in this country now standing at about 1,074,000 officially speaking, according to my Worldometers count anyway, that officialness. That's enough to kill the entire population. As they say, man, woman, and child, but that doesn't nearly cover everything anymore. But every person in 75 of Iowa's 99 counties would be dead as a doornail if that all had happened in Iowa. But she's talking about fentanyl that didn't happen. And I thought, maybe you would want to focus on that. But she can't because she's Republican and red state, yada, yada. So, okay. Over the course of the pandemic, more people have contracted the virus and died of it in counties that voted for Joe Biden in 2020 than in ones that voted for Donald Trump. But that's, of course, because there are more people there. But late last year, the toll in counties that backed Trump by more than 20 points passed the toll in counties that supported Biden by that margin. So, okay, interesting. There's some charts here for you to look at. That's despite those strongly pro-Biden counties being home to more than 30% more people. If we control for population, we see that while infection rates are fairly similar regardless of party, the death toll has been far worse in counties that backed Trump. The counties in which Trump won by the widest margin have seen a cumulative population-adjusted death toll that is 42% higher than counties that backed Biden by the widest margin. In 2020, Biden voting counties overall had 8% more deaths than Trump voting ones, once you adjust for population. But then, of course, they said, don't worry about it, don't stop it. It's only happening in blue counties, except, whoops, it actually will happen in red counties later, over time. In 2021, Trump voting counties had more than 50% more population-adjusted deaths. In 2022, the toll has been about 40% higher per resident in Trump counties. It's often the case that Biden voting counties see more population-adjusted infections in a month, though this is, of course, affected by the regularity with which people seek out and report tests. But the last time there were more population-adjusted deaths in blue counties than in red was in early 2021. A central factor here, of course, is vaccinations. There's an obvious divergence in the death toll in mid-2021 on the graphs shown, one that occurred shortly after Biden and Trump voting counties began to separate on likelihood of vaccination. On the graphs shown below here, June 2021 is indicated with a vertical line to show the point at which the rates of full vaccination began to diverge. And then, after that, was when the Delta variant hit. And then you see what happens. Of course, it isn't only vaccines. The ProPublica story also explores the importance of the right's embrace of unproven treatments for COVID-19, such as the drug ivermectin. When a prominent Republican figure in the state fell ill, her family pushed for the patient to receive that drug and hydroxychloroquine, in keeping with arguments from the political right about the efficacy of those medications as treatments. Elected officials joined the fight, and the patient died. I guess we're still talking about Montana here. The idea that there exist medications that can broadly protect the unvaccinated has been compelling for a few reasons. For one, it allows those on the right to continue to position themselves against the establishment and elites like government medical officials. For another, it suggests that the pandemic was never a big deal as it was made, never as big a deal as it was made out to be. A common argument that is currently most prevalent, that as the currently most prevalent variant, appears to be less frequent in terms of its result in death. I screwed up the reading of it, but you get what I'm talking about. Kills fewer people. The embrace of ivermectin, though, was a potent example of how politics overwhelmed practicality during the pandemic, as I noted earlier this year. That article was thrown back at me repeatedly in recent weeks following the release of new, dubious studies purporting to show that the drug was effective against the virus. For many people, it's more politically or economically rewarding to elevate vague or shaky claims about the effectiveness of random drugs than to admit that the vaccines themselves proved very effective in reducing the death toll. What happened at St. Peter's Health in Helena, Montana, was a microcosm of fights happening across the country, fights often centered on politics and political views. The effect is that even as the Omicron variant allows many Americans to focus attention away from the coronavirus, the virus does more damage in more Republican places. In August, 16 out of every 10 million residents of Trump voting counties died of COVID-19 every day. That's not very many, thankfully, but it's still nearly a third higher than the rate of deaths in Biden voting ones. I just, sometimes kind of think about, it almost rises to wish level where you'd say, well, when is this going to affect the outcome of elections? What if all the Republicans die? Won't we win more elections? But in overwhelmingly Republican states, it's just not going to move the needle, and it's cruel and wrong for you to pin your hopes to it. But anyway, thought that was interesting and brings to mind, once again, even if you don't break it down that way, slowly over time, this is killing an awful lot of people, and to think it's over and done with seems pretty foolish. Just thought I'd remind you of that, but I know you believe that already. All right, let's see. That seems too esoteric to cover, although very interesting and tempting as a Friday subject. I'm going to jump here to Greg Sargent. Seems like a good way to close out the week by alarming you all over again about something you know about very well, but Greg Sargent loves to write about these things, and we're grateful that he does because he writes about them in interesting ways. The hidden danger posed by a MAGA takeover of the House. I can't imagine anything hidden about it, so it's intriguing just for that. What could I possibly be missing, Greg? I'd love to know. But even if I'm not missing it, it's probably well worth reiterating. And after all, it's illustrated with a picture of murdery traitor Green, and that always leads to good things, right? With Republicans favored to win the House, it's still the case, you're already hearing a mind-numbing refrain. Once in the majority, Republicans plan to pursue retribution against President Biden and Democrats. How? By launching all sorts of investigations as payback on Donald Trump's behalf. And remember, I mentioned this yesterday, it used to be the case that the political press was aghast at the idea of people actually even contemplating the idea, hinting that some of their work in Congress might be payback for something, because that's wrong and improper. And Democrats were possibly thinking about it, and so that's horrible. Republicans are declaring it to be their outright intention. Oh, well, it's just Republicans being Republicans. Can't help you. This idea is already getting reproduced uncritically by major news organizations, which is amazing that it could be A, being reproduced, and B, that it could be uncritical, but there it is. The result is to create the impression that Republicans are merely telegraphing plans for some conventional political tit for tat, which is amazing because I remember very clearly that political tit for tat was abhorrent. It wasn't a political convention. It was an aberration. But now it's expected behavior, and so therefore there's nothing you can do about it. But that obfuscates what is more likely the real story. Republicans are prefabricating a fake rationale to abuse their investigative powers in a way that isn't remotely comparable to anything Democrats are doing. Such GOP spin deserves much more serious skepticism. Always true. This reality is pressed on us by a new report in the New York Times that documents just how extreme some of this cycle's House GOP candidates really are. As the Times notes, any GOP majority will probably be narrower than appeared likely earlier this year. A slim majority, plus the fact that the Trump-loyal America First caucus is likely to grow, means GOP leaders will struggle to control their ranks. The Times hints at government shutdowns, debt ceiling defaults, and impeachments of everyone from the president down to, who knows, even the aide who oversees the White House Easter egg hunt. But the threats of a MAGA House takeover is even worse than this. That's because a MAGA-fied House will have another undiscussed tactic at its disposal, using its fiscal and investigative powers to try to defund or hobble any and all investigations and prosecutions involving Trump. How might this work? Here's one way. A GOP majority could reinstate an obscure House rule permitting Republicans to use spending bills to zero out salaries of specific federal officials, or nix blocks of federal employees, functionally killing specific programs. For instance, it might attempt to kill the salary of Attorney General Merrick Garland, or it could try to defund or cancel any ongoing law enforcement investigations of Trump. We need to distinguish this from the tactic of defunding the FBI, which GOP members such as murdery traitor Green of Georgia have demanded. In a more MAGA-fied House, that effort might find support, but most Republicans probably wouldn't back a wholesale dismantling of federal law enforcement. But by contrast, a more targeted attempt to defund specific officials or investigations could be harder for voters to understand and thus more politically inviting for Republicans. It is likely that they would use this process to block investigations and prosecutions of Trump, congressional scholar Norm Ornstein told me. Indeed, Representative Andy Biggs recently floated exactly this idea. It's being talked about. It's real. Obviously, such an effort would be opposed by the White House and the Senate if Democrats keep it, but a faction of House Republicans could threaten to shut down the government while demanding those targeted cuts protecting Trump, Ornstein said. Even worse, they could use debt ceiling fights to try to leverage those Trump-protecting cuts. They could say, well, let's let this whole country go into default unless you stop all these probes of Trump, Ornstein told me. This becomes harder to avoid when you look at GOP candidates likely to win House seats. As the Times details, they include numerous people who already are vowing to use their powers to continue contesting Trump's 2020 loss with sham investigations, among other tactics. Here's another threat. Such Republicans might try to influence the 2024 election. If a corrupt GOP governor were to take over a swing state, like, say, Doug Mastriano in Pennsylvania, and were to certify electors for Trump or an imitator in defiance of the popular vote, a House GOP majority in thrall to Trump could count those electors. Without reform of the Electoral Count Act, that would mean chaos. A lot will turn on whether, as Speaker, Kevin McCarthy, who we'll presume might take over that role, would defy the Trumpist bloc and seek majorities with Democrats. Ornstein's view, McCarthy won't do anything to block or counter the crazies. And, of course, remember what Greg reminded us of the other day, the motion to vacate the speakership. If that's held as a threat over his head, you can be pretty sure he's not going to be too keen on pushing back on the craziest of the crazy. There will be a strong temptation to treat these threats as the Tea Party redux. While crazed opposition to President Barack Obama drove that era's chaos, it was aimed at discernible policy goals such as repealing Obamacare or forcing spending cuts. I don't know. I think they were even crazier than that. But okay, this time will be different. The threats of chaos won't be about realizing fiscal priorities in any meaningful sense. They will more likely be cultishly devoted to preserving one man's absolute impunity. A sizable block of the House Republicans may well see it as a higher mission to put Trump beyond the reach of accountability and above the law. With the House January 6th Select Committee, Democrats are running a legitimate congressional investigation into Trump's incitement of a mob assault on the U.S. seat of government. The Justice Department's search warrant for Mar-a-Lago followed lawful processes and was approved by a judge. If and when the GOP plans in response come into sharper focus, let's not uncritically describe this as revenge or retribution, which is an amazing thing that you could even describe it that way and get away with that. That should be... Anyway, such words take it as a given that GOP conduct will be in some meaningful sense retaliatory for, or even equivalent to, those actions, as if everything is political all the way down and we can't ever distinguish between good faith government conduct and flagrant bad faith abuses of power. There's no reason to capitulate in advance to that.
Kagro in the morning with David Waldman.
Well, like I said, absolutely true, but I think I'd even go further and I'd remind everybody that such retribution, even if it really were tit for tat, used to be beyond the pale, as we said before we decided that that phrase wasn't usable anymore. All right, time for us to wrap up and hand it over to Justice Putnam for his take on Friday next, and we'll see you next week.